The Supreme Court recently denied a stay that would have protected a state's Second Amendment sanctuary law, and now the 8th Circuit is set to rule in this case, and it might get entirely thrown out. So let's talk about what is now happening in this case. Also want to thank the sponsor of this video, which is Kershaw Knives. Kershaw makes some of the best knives available on the market if you're looking for a quality EDC knife. I carry a Kershaw Iridium knife every single day for my EDC, and I cannot recommend their knives enough. And right now, if you go to their website and order using the code 2024 Scholar40, you can get 40% off of your order. So head on over to Kershaw Knives, pick yourself up a quality EDC knife, and thank you again to Kershaw Knives for sponsoring and supporting this two-way content. As I mentioned in the intro, in this video, we're going to be talking about an 8-to-1 order that was issued by the United States Supreme Court and how it is impacting the state's current Second Amendment sanctuary law that's in place in the state of Missouri. The recent Supreme Court order denied a stay which would have protected Missouri's Second Amendment Preservation Act. After that denial order, this case was then sent back down to the 8th Circuit Court of Appeals, who recently heard oral arguments in this case, and they are now set to issue a very critical decision on whether or not Missouri's Second Amendment Preservation Act is in fact valid, or whether or not the lower court was correct in blocking this law. But now the state of Missouri has a new decision that was issued by the 8th Circuit, and they're using it in their favor to have this case completely thrown out in their favor. Essentially, they're arguing now that the federal government cannot sue the state of Missouri and cannot put a block on the Second Amendment Preservation Act that the state passed. Now, for some background on this case and how we wound up now where the 8th Circuit is set to decide this case, back in 2021, Missouri passed a law known as the Second Amendment Preservation Act. This law in Missouri prohibits Missouri officers, agents, and government officials from helping federal agents who are attempting to enforce inconsistent federal laws, essentially laws that violate the Second Amendment. The law uses the 10th Amendment as a basis to refuse state resources, deny those resources, funding, and assistance that would be then used by federal agents to infringe on Second Amendment rights. The law also created a civil remedy where anyone could sue a Missouri official if they helped to enforce a federal law that violates the Second Amendment. In response to this law, the United States government sued Missouri. In the case, the U.S. government sued Missouri under the theory that the law is unconstitutional because the statute is premised on an incorrect interpretation of the Second Amendment. Essentially, the federal government argued that Missouri's super pro-Second Amendment law is unconstitutional and that the government's more limited interpretation of the Second Amendment is instead correct. The government argued that the summary language in the statute made the rest of the sanctuary law pretty much invalid. The federal government also argued that the law here in question does have enforcement mechanisms that essentially bars state officials from engaging in certain conduct. The district court on review agreed with the federal government and struck down the law in its entirety to put a preliminary injunction in place against the entire state of Missouri law. The district court issued an injunction against the statute, and the district court's relief essentially claims to protect state officials from enforcement of HB 85 if they decide that they want to engage in certain conduct, essentially help the federal government put in place certain laws. The Missouri law is similar in nature to a different law that was passed in another state. There was Texas abortion law, which is SB 8, and that was reviewed by the Supreme Court in a case called Whole Women's Health. SB 8 in Texas shielded Texas and its officials from lawsuits since the statute allows only private individuals, to bring lawsuits based on that statute. The enforcement mechanism of the state of Texas law was designed in order to make it harder, if not impossible, to have the law struck down in its entirety. With the Texas and Missouri laws and their structure, you can't get this umbrella injunction against the state or an attorney general, since those individuals and the state at large isn't actually the one enforcing the law. Instead, you would need to get an injunction against the individual persons who are suing under the law, but again, a different person could pop up, bring a new lawsuit, and then you would have to get an injunction or some sort of relief against that new person, and it goes on and on. The Supreme Court found that since the Texas law is not enforced by the state or its agents, then you cannot seek an injunction against those individuals. You also couldn't even get an injunction against a judge who hears one of the lawsuits, or even the law clerks or the clerks of the court who help file those lawsuits. So that's a backdrop of what Missouri did in a similar structure that was in place in Texas that also has a similar type of mechanism where private individuals are the ones bringing the lawsuits. Now, the district court on review of the Missouri law struck down the entire Missouri law and enjoined the state of Missouri and its officers and agents from enforcing that statute. But again, the issue is that the state of Missouri is not actually the ones enforcing the law anyways. The people are. Missouri then appealed that decision up to the 8th Circuit Court of Appeals, and also they asked for the 8th Circuit to put in place an emergency stay on the lower court decision while the appeal is taking place. However, the 8th Circuit denied that emergency request for a stay. That then led the state of Missouri to file an emergency application up to the United States Supreme Court, and they wanted a grant of a stay from the Supreme Court. And we got an order from the Supreme Court which denied that emergency stay. In an 8-1 order, the United States Supreme Court denied the emergency protection of that Second Amendment Preservation Act. Only Justice Thomas was in favor of actually granting a stay to the state of Missouri to protect the Second Amendment Preservation Act. After that Supreme Court denial order, the case was then sent back down to the 8th Circuit, who has now heard expedited arguments in this case. We are now currently waiting for the 8th Circuit to issue their decision. During those arguments, the state of Missouri and the representative first argued that this entire lawsuit brought by the United States government is invalid because the lawsuit does not name a proper defendant. The government is suing the state of Missouri and the Attorney General, but the statute only allows private individuals to enforce this law. Therefore, there is no proper defendant in this case. They also go on to state during the arguments that the United States government cannot identify a single act that the state or its officers or agents are actually engaging in that is harming the government. Now, after those arguments, the state of Missouri has now submitted a letter to the 8th Circuit on why the federal government does not have standing to sue them based on a recent 8th Circuit decision that again was issued by the same court. The state argues that since the federal government does not have standing, the entire case should now be thrown out. In this letter sent to the 8th Circuit by Missouri, Missouri states that in the Ark of Iowa versus Reynolds case, the court concluded that plaintiffs failed to establish traceability when they sued the governor and director of Department of Education over a statute, which prohibits mask requirements in schools unless otherwise required by law. Plaintiffs failed because they have not shown that the defendants have a duty to enforce the statute or that they have attempted to enforce it. Any injury stemmed not from the governor or director, but from schools that did not impose mask mandates. Similarly, here the United States has not shown that the defendants have a duty to enforce the Second Amendment Preservation Act, or that they have attempted to enforce it. If the United States has an injury, it stems from the threat of enforcement by private individuals. The United States seeks relief against the governor and the attorney general in federal court in the hope that state courts adjudicating suits by private plaintiffs will find a federal opinion persuasive. That is not enough for redressability because private litigants, this court has concluded, will not be constrained by any injunction that could be issued against the state officials. In Ark of Iowa, this court also concluded that plaintiffs could not assert rights that it believed schools had because that dispute was between the state and the school districts. But the United States has done that here. It has, in effect, asserted not its own rights, but rights that it believes political subdivisions in Missouri possess. That is why the district court's judgment frees state agencies, not the federal government, from regulation. It reads, state and local law enforcement officials in Missouri may lawfully participate in joint federal task forces, assist in the investigation and enforcement of federal firearms crimes, and fully share information with the federal government without fear of HB 85's penalties. So here, this letter submitted to the 8th Circuit by the state of Missouri essentially is pointing to a new decision in the 8th Circuit. And again, this points to the fact that the federal government cannot seek relief against states since the state here and the attorney general and the governor are not actually the ones enforcing the law. Instead, it's only the private individuals that are engaging in these types of lawsuits, and they're the ones that have the authority under the law. Based on this, the state of Missouri is arguing that the standing requirement has not been met by the federal government and that the 8th Circuit should throw this entire case out. Now, this is very interesting. It's new developments in this case. It's new 8th Circuit precedent that was issued, and now it's being used by the state of Missouri to support their position that the federal government cannot bring this lawsuit against the state and cannot put this type of block on this Second Amendment Preservation Act that was passed in the state. So again, something we're going to be watching closely to see how it develops. But if you guys like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.